We'll call the meeting to order for this meeting with 5 members, and one will be sworn in just a moment. With 5 members present, we do have a quorum, and I think the first order of the day would be to swear in our new member, Mr. Randy Ponson.
Randy, will you raise your right hand? Do you solemnly swear or affirm that you will support, protect, and defend the Constitution and the government of the United States and of the state of Florida?
Yes, I do.
We got her?
All the cool guys on the block have dumpsters.
The Board of Adjustment, BOA, hears administrative appeals, variances, and conditional use requests. These hearings are quasi-judicial in nature. Quasi-judicial hearings are like evidentiary hearings in a court of law, however less formal. All public testimony will be taken under oath, and anyone testifying before the BOA may be subject to cross-examination. All documents and exhibits that the BOA considers are entered into evidence and made part of the record. The giving of opinion testimony will be limited to experts, and closing arguments will be limited to the evidence in the record. After hearing the testimony and arguments for and against the proposed action, and before making its decision, the BOA will consider the relevant testimony, the exhibits entered into evidence, and the applicable law. Because decisions of the BOA relating to variances, conditional uses, and extensions of a development order for site plan or approval are final, unless overturned by a court of competent jurisdiction, the county may issue development orders and permits for properties in accordance with the decisions of the BOA. However, if the applicant requests the issuance of any such order or permit, and such order or permit is issued, the applicant and not the county shall bear any risk that such decision may be set aside, the development order or permit may be revoked, or the development may be otherwise enjoined by the reviewing court. Any applicant for relief from a decision of the BOA for said actions or any aggrieved party as defined by the law may seek review of such decision by filing an appropriate pleading in a court of competent jurisdiction within 30 days of the BOA decision. The date of the BOA decision shall be the date the BOA voted at the conclusion of the hearing. Whenever the BOA denies an application, no new application for an identical action on the same parcel shall be accepted for consideration within a period of 180 days of the BOA decision. Any person aggrieved by a decision of the BOA relating to an appeal of an administrative decision may within 15 days thereafter apply to the circuit court for review. Each individual who wishes to address the board regarding a particular issue must complete the blue request to speak form and submit it to the clerk for review. These forms are located in the back on the table of the commission chamber. You will not be allowed to speak until we receive one of these completed request to speak forms. We must have these completed for the public record. All written or oral communication outside of this hearing with members of the BOA regarding matters under review today are considered ex parte communications. Ex parte communications are presumed prejudicial under Florida law and must be disclosed as provided in Board of County Commission Resolution 96-13 before a decision by this board or on any administrative appeal, variance, or conditional use request. The chair will ask, as each case is heard, that any board member who has been involved in any ex parte communication regarding this respective issue to please identify themselves and describe the communication. Would you swear in staff?
Please raise your right hand. Do you solemnly swear and affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
I do.
The board has previously recognized staff as expert witnesses. Does anyone have any questions regarding their qualifications and abilities to offer expert testimony? The BOA meeting package dated January 19, 2022 with the Development Services finding of fact has previously been submitted to the board. The chair will now entertain a motion to accept the BOA meeting package into evidence. Do we have a motion?
Motion.
Motion by Willie. Do we have a second?
Second.
Second by Marty. Those in favor signify by raising your right hand. It's accepted unanimously. Motion passes unanimously. Do we have proof of publication?
Yes, sir.
Did the publication meet all the legal requirements?
Yes, sir.
The chair will entertain a motion to waive the reading of the legal advertisement. Do we have a motion?
Motion.
Motion by Willie. Do we have a second?
I'll second it, Mr. Chairman.
Motion by Michael. Those in favor signify by raising your right hand. Passes unanimously. Members of the board, have you reviewed the resume and transcript of the Board of Adjustment meeting held on December 15, 2021? Upon your review of the resume and transcript, are there any additions, deletions, or corrections? Seeing none, they're accepted.
Can we make a motion on that, please?
Yes, could we have a motion, please?
Motion.
I'll second it, Mr. Chairman.
Willie, second by Michael. Those in favor signify by raising your right hand. Passes unanimously. Our first case is conditional use 2022-01, the address at 5950 9 Mile Road. The request is to allow on-premise alcohol consumption within 1,000 feet of a place of worship. Board members, has there been any ex parte communication regarding this case? Seeing none. Does any board member intend to refrain from voting due to a voting conflict of interest? Seeing none. Would the individual to a party to this item come to the podium and identify yourself by stating your name and address for the record? And you're an attorney, so you will not have to be sworn in.
I am, thank you. Meredith Bush. I'm a certified land use planner and an attorney at Clark Partington. My address is 125 East Intendencia, Pensacola, 32502. And I'm here on behalf of the applicant.
Thank you. And you understand all the criteria must be met in order for the board to grant this conditional use.
Yes, sir.
Would you like to give a little summary of?
Sure, I'll be happy to. Good morning, and I appreciate your time. We are seeking conditional use approval. The approval is necessary for the service of alcohol within 1,000 feet of a place of worship. The anticipated use of the site is a mix of retail and service, the service being a restaurant, primarily burgers and pizza, but with beer on tap. And, therefore, because of the proximity to the places of worship, the conditional use approval is required. I'm happy to walk through the criteria at this stage. Staff's recommendation and their findings do support our request, and staff is recommending approval. But if you'd like.
If you don't mind, we'll let the staff go through the criteria and then ask you to come in again later.
Beautiful. Thank you so much.
Thank you. Does the board have any questions of the applicant at this point? Seeing none, would the staff make their presentation, please?
Hi, my name is Christina Smith. I'm an urban planner 1, and this is for case CU 2022-01, address 5950 West 9 Mile Road. It's for conditional use to request to allow for alcohol on-premise alcohol consumption within 1,000 feet of a place of worship. This is the location map for the property. And this is the future land use, which is mixed use, suburban. And this is the zoning map, which is LDMU, low density mixed use. This is an aerial map of the location showing the 2 places of worship nearby. This is a public hearing sign on the property. This is looking east along 9 Mile Road. This is looking onto the subject property. And this is looking south across 9 Mile Road. And this would be looking west from the property. And then here is a copy of the proposed site plan that was submitted for the pre-application. Okay, so criterion A, general compatibility. The applicant proposed that the hours of operation for the restaurant are tentatively between 10 a.m. and 10 p.m. The 1,000-foot minimum distance is not achieved. There are 2 places of worship that are in the vicinity of the proposed use, which were on the aerial map. The buildings will be visible to each other. Alcohol consumption will be limited to indoors. On-premise alcohol consumption is limited to inside the existing restaurant building as stated by the applicant. No outside consumption of alcohol is proposed. And there are conditions or circumstances that would help mitigate any incompatibility, and that would be the proposed use will be indoors. Criterion B is the facilities and service. Facilities and services for the restaurant are being developed. There are services to the site that provide adequate capacity for the proposed use. There's an ECUA force main located directly in front of the property. Potable water, sanitary sewer, and solid waste disposal are available to the site. Criterion C, on-site circulation. The existing ingress and egress from the site will be utilized. The applicant will need to submit the necessary FDOT driveway connection permits or safety upgrade permit as may be required. Criterion D, nuisances and hazards. The proposed use should not generate unreasonable noise, glare, dust, smoke, odor, vibration, electrical interference, or any other nuisances or hazards for adjoining properties and other properties in the immediate area. Criterion E, solid waste. Solid waste services will be provided to the site. All on-site solid waste containers will be appropriately located and screened from off-site visibility. Criterion F, screening and buffering. The project will need to be approved through the site plan review process and meet the following DSM criteria for screening and buffering between uses. The applicable DSM criteria. Criterion G, sign and lightings. The proposed signage and lighting will be assessed during the site plan review. Lighting should be directed inward to avoid impacts to adjacent properties. Criterion H is site characteristics. Based on the applicant's submitted plan for development review pre-application, the size, shape, and location of the parcel will accommodate the proposed use. And then criterion I, use requirements. The parcel is an LDMU zoning district, which allows restaurants, including on-premise consumption of alcoholic beverages. And then the staff findings, the staff recommends that the board approve the proposed conditional use as requested.
Thank you very much. Does the applicant have any questions of staff?
No, sir.
You concur with the findings?
Yes, sir.
Okay. We have several speakers, and if you will, we try to limit addressing the board to 3 minutes per person. I'll call on Mark Davis. Please come to the podium, state your name and address, and be sworn in.
My name is Mark Davis. I live at 2931 Angus Circle, Molino, Florida, 32577.
Please raise your right hand. Do you solemnly swear and affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you.
Good morning. I appreciate the opportunity to stand before you today to speak in opposition to this. I am the pastor of the church right next door to where this is located. Our property is not divided by anything but a fence. So our property is right against one another. To sell alcoholic beverages right next door to the church goes against the ordinance that's in Escambia County. It also goes against our doctrinal beliefs. We train and teach our people that alcoholic beverages, the consumption of it, is not biblically sound. And so for you all to say that now we're going to put it right in your face goes against what we've been teaching our people there at our church. And so I would say to you today that I would encourage you to say no to this. There's plenty of room throughout Escambia County for restaurants to be located that's not next door, not just in the general area, but next door to a church, as well as just up the road from a middle school. There are 2 places of worship right within that variance, and so we would encourage you to say no to this. And again, because of our doctrinal teaching, it stands against what we believe, that alcoholic consumption is not right, it is wrong, and now to encourage it from a county standpoint is also just as wrong. And so today I stand as an expert on the biblical precepts that we have before us. I brought my manual, which is the Word of God, and I'd be willing to show you right where the Bible says that we should not consume alcoholic beverages, and I'd be glad to answer any questions that you may have.
Any questions of Pastor Davis from the board? Does the applicant have any questions of Pastor Davis?
No, sir.
Thank you, sir. We may
Thank you.
address you later.
All right, thank you.
Tim Barnes. State your name and address and be sworn in, please, Mr. Barnes.
My name is Tim Barnes. I live at 2155 Cliffbrook Avenue, Pensacola, Florida, 32526.
Please raise your right hand. Do you solemnly swear and affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
I just wanted to say that we have the ordinance for a reason. The people that set the ordinance had a support to come up with the ordinance, I'm assuming. And I've been in Escambia County since May of 1965, and I've traveled a lot. I've been on every habitable continent on planet Earth, and I've been to a lot of big cities and all over this country. And I retired to Pensacola out of the Navy after 22 years for a reason, because I like Escambia County, and I like the size of Escambia County and the feel of Escambia County. And I don't want to live in Miami, and I don't want to live in Jacksonville, and I don't want to live in those big giant places for a reason, okay? And so I don't understand the logic at all of why we need to make an exception to have alcohol right beside a church, especially in Escambia County. It just doesn't make any sense to me. There's plenty of places to put a restaurant, and it doesn't have to be right beside our church. That's all I have to say.
Thank you. Board members, any questions of Mr. Barnes? Applicant, any questions of Mr. Barnes? Staff, any questions of Mr. Barnes? Thank you, Mr. Barnes.
Thank you.
Doug Nellums. State your name and address and be sworn in, Mr. Nellums. Thank you.
Yes, I'm Doug Nellums, 3013 Pine Forest Road, Cantonment, Florida, 32533.
Please raise your right hand. Do you solemnly swear and affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
Yes, sir, I'm obviously opposed to this recommendation as stated by our pastor. But another concern that I have is that when we allow the infringement upon such rules as this, I believe it opens the door for more infringements and maybe taking over and losing our rights that we have already. I'm just afraid that this is going to create more problems for other churches. I don't know if this situation exists in other areas of Pensacola, but I'm afraid it does to infringe upon this right that we have. That's all.
Any questions, board members, of Mr. Nellums? Staff, any questions of Mr. Nellums? Applicant, any questions? Thank you, Mr. Nellums. Richard G. Mills.
My name is Richard G. Mills. My address is 2480 Interstate Circle, Pensacola, 32526.
Please raise your right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
Excuse me. This ordinance that has been standing to provide for 1,000 feet difference from distance from between religious organizations and bars, places that alcohol is consumed, obviously was established for a very good reason. It's been long-standing, and I think it's a very dangerous, slippery slope to stand on providing for variances in this situation. And I think that it's pretty common knowledge that there are probably a lot of other places more suitable where bars and restaurants could be placed. And I just don't think there's any good, sound, logical reason for forcing a bar to be right next door to a church that doesn't want that bar to be there. And I think that if this variance is established, there will be other churches throughout the community, as well as possibly schools, where people will come forward and request variances. Once you've established a precedent for a variance here today, if you do, and I hope you don't, then that would set a precedent for doing it at other places. And that's all I have to say.
Thank you, Mr. Mills. Any questions, board members, of Mr. Mills? Any questions from staff? Applicant, any questions? Thank you, Mr. Mills. Mark Gibson.
Good morning. I'm Mark Gibson. My address is 1408 Glenmore Drive, Cantonment, Florida, 32533.
Please raise your right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
I have a letter I'm going to read, and I'm going to present this to you. I'm chairman of the board of the First Church of Christ Scientist in Pensacola, which is the second church that is involved in this action. And I have a letter that I'm going to read to the Board of Adjustments for this case number. On behalf of our church membership, the Board of Directors, First Church of Christ Scientist, Pensacola, does hereby unanimously object to the conditional use proposed by the subject case number. We are solidly in support of the Land Development Code, which prohibits the proposed use when the vicinity of a church is encroached. Not only is the use within the prohibited zone of 2 churches, but it is also in close proximity to a middle school. Our faith is built upon serving the one and only God in the way that Jesus Christ demonstrated and showed us. We deny any power that is opposed to God, purity, or has power to influence others erroneously. Thank you, Mark Gibson, Chairman, Board of Directors, First Church of Christ Scientist.
Board members, I believe it would probably be in order at this time to, for a motion to accept this letter from the church.
Mr. Chairman, I move that we accept the letter from the church into evidence.
We have a motion by Michael. Do we have a second?
Second.
Second by Willie. Those in favor signify by raising your right hand. Passes unanimously. Thank you, sir. Do you have any other comments?
No, sir.
Thank you. Board, any questions? Staff, any questions?
No, sir, we have the hard copy. No objections on this side.
Thank you, sir. Any questions? No questions. Thank you.
Thank you.
Thank you, sir. Ellen Odom.
Good morning, Ellen Odom. I'm General Counsel to the Escambia County School Board. I don't know if I need to be sworn in. I indicated on my form that I am neither for nor against. We found out about this yesterday, so I do not have the authority to speak on behalf of the entire school board, but I was asked to look into this matter by our board chair, and so I'm here doing our due diligence. As several people have mentioned, this is in close proximity to Beulah Middle School. It is in fact within the not the entirety, but a corner of our property is within the 500-foot range from the cited property. But because of the way the Land Development Code is written, the way it's measured for proximity to a school, it's the customary path of travel for a pedestrian in the proper right-of-way. So what that would mean is for us to be within the 1,000-foot zone, a student would have to walk from our school up to Beulah Road and then back around on the other side of the road to reach the subject property. We would like some assurance that the school's proximity was taken into account. We would like some assurances that those measurements were in fact made. I do appreciate the comments regarding the use for which this is going to be put, because of course our board members have been presented with information that this is going to be a bar. And what I saw, and I applaud you representing a governmental entity, I appreciate the ease with which I was able to access these materials. So I was pleased to see that it does appear that it is going to be a restaurant, but I would like to know whether or not it's going to be a beer and wine license. Is it going to be a full liquor license? You know, what the exact parameters of this are. Is it going to be a true restaurant insofar as it receives 51% of its proceeds through the sale of food? And I did want to make sure that you all were aware that there are some discussions being had about creating a walkover for students to get safely across 9 Mile Road from the school. In discussions with some members of the county, I'm not at liberty to say who they are because I've not, didn't ask permission to reveal the conversations that I had. But if that walkover were in existence today, then the subject property would clearly be within the 1,000-foot zone. And I would note that there is no conditional use exception for educational facilities within 1,000 feet. So, thank you.
Thank you. Staff, the question Ms. Odom has on, did the county measure the distance to the school?
Yes, sir, and I can clear up a number of things that have been stated. One, yes, it was measured. The measurement is as on your screen. It is within the shortest route of ordinary pedestrian travel within public rights of way from the main, sorry, it's feedback. Within the, from the main entrance of the place of business to the main entrance of the place of worship or child care facility, or for an educational facility to the nearest point of the grounds in use as part of the facility. That being said, the measurements that we have taken in our GIS, you would have to go down to Beulah to the nearest traffic control device. There's a light there. 100-foot right-of-way, it's 940 feet from the center of this property, because we do have a preliminary site plan. I don't have the exact front door location, but when we're talking thousands of feet, it's so far out, that's not really a concern at this point. It's 940 feet to the Beulah light. You have 100 feet of right-of-way, then you would go back for a total of 2,427 feet to the nearest point of the school grounds. I also checked if Rebel Road were to have a traffic control device. This is a DOT road, 1,700 feet back to Rebel, then across and to the nearest point of the school grounds, which would be their parking lot. It's 2,009 feet. As far as the crossover, if the crossover was in place, or even if it was an approved project as of this point, we wouldn't have even accepted the application, because that's clearly a means of.
I absolutely concede that is something that is in the concept phase. It is nothing that is approved, but I did want to make you aware that it is something that's being considered to address our student safety, walking safety.
And if it was up to me, there'd be a light there just for student safety, but I'm not state DOT. And I'm sorry about this feedback, y'all. Should I try without it and just, everybody hear me?
I think it went off when I turned mine off. I have a question for you when you get through.
Okay. So the other thing about measurement, so this is not a variance, this is a conditional use. Variances are based on dimensional things like setbacks. Conditional uses deal with the individual land use. As far as measurement from a church, it's front door to front door. I measured from the farthest corner of this property. There's no way it's going to go out 1,000 feet of the church immediately next door. As for types of licenses, county breaks it down. If you're within that distance, as on-premise consumption, you need conditional use approval, and a liquor store would need conditional use approval. Package sales, I know, same active ingredient, but that's the way it's written. What wouldn't need any sort of separate approval is off-premise beer and wine sales, what's called a 2 APS license. Those can go right next door to a church, right next door to a school. You have a Dollar General next door to the school, 2 APS license. Someone can go in there and purchase whatever kind of alcohol they sell there. Doesn't need any separate approval. Same thing with the church, it could be right next door. The conditional use is specific because of proposed on-premise consumption. And that's what got us here. Now, as to the specific license types that they might be seeking, I would refer to their agent for the future plans for the site. At this point, we simply have a preliminary site plan, and they're requesting this land use approval.
Mr. Chairman, I think I have a question at this point. In theory then, if I understand your testimony so far, is that if we grant this approval, then later when the entity seeks its licensing, then it could, once our approval is given, it pretty much is up to the business itself to choose the type of license. Is that right?
Correct. They're gonna come in with whatever license they seek. But this is, the conditional use is specific to on-premise consumption. It's a conditional use. This board is here for the reason you can apply conditions upon that as you so wish. The applicant has proposed limiting hours of operation. Anything along that line is within your purview.
Well, if I understand the testimony, the hours of operation are gonna be like from 10 a.m. to in the evening. Yeah, which is well within past the school day. Mr. Chairman, I'm gonna have some questions, but I don't wanna hold up,
I have a question for
the school board. Generally, what is their position on these kind of cases? I understand they haven't taken a position on this.
I am not at liberty to speak on behalf of the entire board. And frankly, I can't speak on behalf of individual board members unless I've had those conversations with them specifically. I don't know that this situation has arisen. And like I said, this is kind of a unique situation because the school is in very close proximity to the sited property. But again, because of the way the land development code is written, that you have to walk this huge circuitous route, if, as the crow flies, it's within 500 feet. But I realize that, you know, the land development code is what it is, and words have meaning, and that's the way the county has decided to configure that particular provision of the conditional use provisions. But I am not aware of a situation in which this has occurred. I was the general counsel to the school board back from 2004 to 2007, and just came back in April of last year. So I don't know that this situation has arisen. But I really am not at liberty to say how the board would respond to situations such as these.
I have a question, Mr. Chairman. Just curious, what time the school let out? What time does it begin? And do you have any walkers that walk home?
We do have walkers, and frankly, that's one of the reasons why we're looking into, I'm sure if any of you guys have driven out by that area, the growth is amazing, and the amount of traffic is remarkable. We do have walkers, and that is one of the reasons why we are looking into the possibility of doing a walkover out in front of the school to make sure that the students don't have to walk all the way down to Beulah Road to get safely across the street. As far as what the school hours are, that is a moving target. Because of COVID, we've had to stagger our school start times in order to ensure bus driver coverage. I want to say that they probably, and again, this is a guesstimate, but I would say that school generally is starting, I know some elementary schools are starting as early as maybe 7:15 in the morning, and getting out as early as 1:30. Then there are other schools that are starting a little after 8, and then get out at 3.
Thank you.
Board members, any other questions of Ms. Odom? Staff, any questions?
Not necessarily a question I'm going to try with this mic. The most recent thing that you've had that was in any way similar was a brew pub on Olive Road, on the south side of Olive Road, within the general vicinity of Ferry Pass Middle School. That one was outside the measurement just barely, but they at least had a crosswalk on Olive. Mind you, Olive is county and it's not as heavily traveled right now as 9 Mile Road, but there was at least a crosswalk to measure through, but it was still outside the measurement.
Any questions of staff, board members? Applicant, do you have any questions of the speaker?
No, sir, not on this item.
Okay, thank you, Ms. Odom.
Thank you very
We may
much.
call on you again. Clay Mather.
Hello, I'm Clay Mather. I live at 8700 Klondike Road, 32526.
Please raise your right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
All right, well, thank y'all for having me here. I know y'all have to listen to a lot of people that are probably very disgruntled. I own the mobile home park and the 8 acres directly next to this parcel of land. And I am opposed to this for many reasons, one of which is we have about 22 units there, and half of which have children. And it has grown exponentially because of the growth in the area, with the amount of families trying to move in closer to good schools. Therefore, I've recently had to build a bus stop because of the amount of children and families that sit at the bus stop right there, which is probably, I'd have to say 75 feet from this proposed restaurant. So I would have to be opposed to the open consumption. Two, because common sense would tell you that this is going to push the hours of operation late into the night. And I'm not for government telling people what they should do with their land, because honestly, if they want to build whatever they want to build, I think they ought to have the right to do it. However, if you grant conditional use, and let's say 6 months from now this business goes out, since that conditional use has been granted, can now a full-fledged bar come in and stay up till 2 and 3 o'clock in the morning? You know, these are questions I don't know the answers to. In restaurants and businesses in these little places like this, you know, they'll go out 6 months to a year, they can, potentially. Does that also leave the door open for the next business to come in with the conditional use being granted, saying, okay, well now we can run a bar till 2 or 3 o'clock in the morning? I mean, who says no to that? That's probably about my biggest concern, is we have multiple mobile homes that are going to be within 100 feet of the operation of this business. Half of those are elderly, and if you're talking about running until most restaurants that I've been in that didn't serve alcohol closed between 7, 8 o'clock, maybe 9. If you serve alcohol in a restaurant, they'll usually go up to 10, 11 o'clock. And to be so close to dozens and dozens of homes, half of which are elderly, and I mean when I say close, 75 to 100 feet, that's going to propose a problem for me trying to keep my tenants happy, that there's a lot of noise, and if it serves alcohol and it is a bar setting, it will be loud. There will be loud music, and I get that, except this is a very, very small piece of land that is wedged in between the church and this mobile home community. And I'm not for telling people what to do with their land, but having this particular conditional use granted could propose a problem for this mobile home community next door. And that's it. Thank you.
Thank you, Mr. Bowden. Any questions, board members of Mr. Bowden? Staff, any questions?
Just something to point out to the board. The request is for a restaurant license. The request is for a restaurant license. You'll find the staff findings recommendation was as submitted. It is as a restaurant license. It is completely within your realm to say this is limited strictly to a restaurant license. That's completely up to this board as a conditions you can impose on any case that comes before you. LDMU, the current zoning on site, does prohibit bars and restaurants. Bars and nightclubs. So, but the conditional use is specific for a restaurant. Let's say it gets upzoned in the future, the conditional use on this site that runs with the land would be through whatever conditions would be imposed by this board.
Board members, any questions of staff? Applicant, any questions of staff or the speaker?
No, sir.
Thank you. Thank you, sir.
Yes, thank you.
Cindy Mather.
Cindy Mather, 8640 Klondike Road, 32526.
Please raise your right hand. Do you solemnly swear and affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you.
My concern is Beulah is just a very, very small area. We have one developed intersection. Of the developed intersection, 3 corners are developed. You can get all the alcohol you want at any of those 3 sections. You can just go down the road just a little bit more and get more alcohol. I realize this is for open consumption, I get that, but I really, my concern is that property is very small, wedged right between the home of many children as well as a church. And I think the congestion of I just think this could morph into something bigger than just a little restaurant with the sit down and beer on tap. And that's my concern. Thank you.
Thank you. Any questions of Ms. Mathers? Applicant, any questions? Is there anyone who failed to fill out a blue sheet and would like to speak? I guess I've been on this board 14 years, I think, and we have had cases involving places of worship within 1,000 feet and have often approved that conditional use. However, I can think of very, very few have we approved when the place of worship objected to it. And I think, as the speaker pointed out, there's a reason for the ordinance. And just to satisfy the need of a business to circumvent it, I think we need to look very hard at that.
Mr. Chairman, I have some questions if the applicant, Ms. Bush.
Yes, sir.
I've got a couple of questions I'd like to, maybe you could help us with, or help me with anyway. First of all, what does this proposed business generally, to your knowledge, intend to serve as food?
To my knowledge, there's a letter of intent for the lease of the building from a restaurant chain that their main fare are burgers and pizza, things like that.
Okay, so it would be like tacos, those sorts of
I don't know.
fast food kind of.
No, certain. Well, not fast food, but I mean, it's not a steakhouse. It is really a diner type,
So this
classic
is
diner.
So this is not like an Outback or a Red Lobster, anything like that.
It is a national chain, but it's not one of those.
Yeah, I understand, but I would not those in particular, but that style is what I'm getting, where you would actually have a meal, a full meal.
I would liken it to, I would say Applebee's only because of the type of food being served, but it's not that. Almost like a steak and shake, except that there's a beer service, alcohol
Right.
service as well.
And if I understand, it's been a long time since I've even thought about this, but as I recall state law, in order to get a restaurant license and to be able to dispense alcohol, then you have to show that more preponderance of your revenue is going to come from food sales.
Absolutely. One other thing, the Land Development Code is very clear on the definition of what a restaurant is, what a bar is, what a nightclub is. And this clearly falls within restaurant. The primary purpose of the establishment is the service of food with an option, a beverage option. It's not a place that you would go in simply to drink. It's a more of a family-style restaurant.
So, I know you're not testifying, so I won't say testimony, but your understanding is therefore, based upon what you just said, is that the major revenue would not come from alcohol sales, but would be from food, is that right?
Correct. That's correct.
And, is it literally true that this proposed site is across the fence, as the testimony, if I recall, from the church, a church?
It is directly adjacent to one of the church properties. There may be a fence there now. As part of the site plan process, we'd be open to any additional buffering or screening requirements, but I believe there's a fence between the two properties.
And will this establishment be open on Sundays?
I believe so.
So they would be open during the time, I would imagine, that these houses of worship have services. I'm assuming that they would be around lunchtime.
There could be some overlap. If the church service starts at 9 or 10 in the morning, the restaurant may not be open at that hour. However, if it goes on till, 11, 12 in the day, or if there's an evening service, then the restaurant very well could be open at the same time.
And you're, I don't exactly know how to ask this. You're fairly certain that alcohol will be a secondary source of revenue or activity, and that food will be the main thing that will be offered to the public?
Yes, I'm confident of that it is a food service establishment that also offers beer as a beverage. And I'm trying to recall, to be honest, I looked at the website and menu prior to the hearing for the company that has the letter of intent or that's under contract as a potential tenant. I don't even recall if they serve wine. I believe it may just be beer. However, we would not be limited. I mean, the license, I believe, would allow for service of alcohol.
Okay. And I'm sort of gotten the impression from reading the file last night that this is sort of more of what we would call a sports bar kind of thing.
A sports bar, no sir. So a sports bar, in my understanding, would have alcohol more as a primary focus. You'd have the large TVs and
Right.
go watch sporting events. This is a small location. It's a small space, and it really is more of a burger joint.
Okay.
I know that I'm trying to think without, giving away the, because I'm just not at liberty to disclose the contract. I'm trying to think of similar establishments, but no, sir, it wouldn't be a sports bar. It is a true restaurant. You go in, you order a burger and fries, pizza, stuff like that, appetizers, order a soda, order tea, but an option would be that there would be alcohol service.
Thank you, ma'am.
Okay. And at what point will I be allowed rebuttal for these speakers? I don't know if this is an
Now.
appropriate time. Okay, great, thank you. I would just say that we do have the ordinance in place for a reason. However, the ordinance that is in place does allow for conditional use for the service of alcohol within 1,000 feet if you meet the criteria. We have met those criteria. Those are established by code. Our submittal meets those. The county has reviewed our submittal and agrees that we meet that criteria. And nothing presented today overwhelms that criteria or contradicts our meeting that criteria. The objections are an objection to alcohol in principle by the church, things of that nature. We did consider the school. At the pre-application meeting, there was discussion about the school and about the measurements. But it is the true path of the pedestrian walk, which we're well outside of the over 2,000 feet away. A state road, I mean, that may take a couple years before a crosswalk or anything like that is permitted. So the other thing is simply to just reiterate that the code clearly defines what a bar is, what a nightclub is, and what a restaurant is. Within low-density mixed use, bars and nightclubs are not permitted by the zoning. So we couldn't come before you and ask for that. If the restaurant fails, a bar or nightclub wouldn't be allowed to come in. That's not a permitted use in the zoning district. So your approval would be strictly for a restaurant that would allow indoors. There's no outdoor seating contemplated, but indoor service of an alcoholic beverage with whatever other food is served. If the burger place doesn't make it, you know, if a Mexican restaurant or something were to come in, it would still be indoor seating, primarily service of food with alcohol as an additional beverage. Based on the fact that we've met the criteria outlined in the code and that staff agrees and recommends approval, and that the presentation by members of the public, while emotional and moving, and you know, I understand their concerns, again, it's not enough to overcome the fact that we've met the criteria and staff has recommended approval. This is a quasi-judicial proceeding, so I would respectfully ask that you grant the approval requested. I'm happy to answer any other questions you may have.
Questions, board members of the applicant?
I have a question for staff.
Question for staff.
If, clarify this situation, would the restaurant have to come back to the county or to this board if they wanted to have outdoor serving?
Correct. Sorry about the feedback. The way this works, they're still going to have to come through development review for the buildings, the shopping plaza, I guess we call it at this point, or office, whatever it's going to be. Any internal things would not. I mean, if they say, well, we're a restaurant, yes. You know, if that's part of the overall development, it doesn't have to come back through development review again for internal things, but it's very specific in the license paperwork from the state as to whether or not there is outdoor seating. If they were to change that, yes, they would have to come back through to get approval again to have the outdoor seating added, because that wouldn't be part of a license where they're requesting just the indoor portion. And again, you are here to be able to ask for or impose conditions should you so wish. I know the question came up about buffering. I would direct you to this photo here. As you can see, currently, this is the church immediately next door. Currently, on this being a vacant residential site, there's a chain link fence that goes around the property in question. There's a what appears to be 6-foot privacy fence on the church's side of the property. That's what's there now. Anything that comes in through as a development would need to meet the county's minimum buffering standards. Given the uniqueness of this use, if this board were looking in that direction, you could go above and beyond those minimums.
I have a question too. If this establishment, proposed establishment, did not serve alcohol, would they need a conditional use?
No, sir. It's specifically because of the distance from the two places of worship.
So if they did not have any kind of alcohol sales, then they would have a right, the opportunity to go ahead and do whatever they wanted to do to build a restaurant.
Restaurants are allowed by right in low-density mixed-use zoning. It's specifically the distance from the church. If they were outside 1,000-foot distance, they could still have, by right, in that zoning district, on-premise consumption for a restaurant.
Right, but in this particular case, if alcohol sales weren't involved, then they would be able to proceed with their project.
That is correct.
Okay. I guess that leads us to the next question. If we can, this project, or do we have the ability to approve the project without alcoholic sales?
The conditional use is based strictly on that on-premise consumption. There's nothing to approve if there's not on-premise consumption.
Board members, any questions of?
I have a question for staff. Can you give me a kind of a short history on this 1,000-foot rule, how long it's been around and where it came from?
I got here in 2006, the rule was in place. The 1,000-foot, at that time, it was different in two ways. One, it was a buffer, a 1,000-foot buffer from the property boundaries. Two, it was a variance at that point in time. County made changes over the years. One, making it a conditional use, because a variance, you have to provide how it would be a hardship and nothing else could be done with the property. Well, lots of restaurants don't have alcohol, so there really wasn't an option for any sort of recommendations of anything but denial as a variance. A conditional use, though, opens up more towards conditions could be imposed, and it deals more with compatibility of adjoining uses as opposed to that hard and fast hardship on the property rule. The measurements were changed from the radius to the walking distance just to keep the county's two different ways of, at the time there were two different ways of measuring. Code of Ordinances had the walking distance, and I believe that was strictly related towards bottle clubs. But we had two different methods at the time. So the county went with just take one method, the one that is used most commonly in other jurisdictions, of that walking distance along the right of way. So those two changes were made at that point. We do get some of these each year. We get a couple of them. We've had those that have been controversial. We've had ones that haven't been. Quite frankly, when no one shows up, it doesn't help out very much. You know, staff can't be everywhere and aware of every situation, which is why it's good that we were sending out the notices, because we need the people who live around there and are most affected to come and have a say. You need all that extra information. It just depends on the churches involved in the location and or daycares as to what sort of turnout we get, what sort of public involvement comes through. And this one is as it is. I mean, it's directly next door, so.
Any other questions, board members? Staff have any additional info that you would like to present?
No, sir.
Applicant, any further comments or summary or anything you would like to do? I realize you have.
Only briefly, I would point out that the restaurant is as of right, and it is, as Drew mentioned, just the initial uses for that service of alcohol. However, if you look at the site plan, there are two buildings proposed. It's a whole plaza development. The restaurant will be within a plaza development that food. And in this case, we're asking that it also be allowed to serve alcohol, so it's not an intent to come in and put a busy bar or nightclub type atmosphere beside the church or, you know, near the school. It is truly a development where you can go, you can take care of business, you can grab a bite to eat. You know, there are limited food options out in that area, and as part of the request, we will be asking for the authorization of alcohol.
Thank you. Question?
For staff, if we were to require additional buffering, how would we define what additional buffering is, or do you have levels of buffering that you would impose?
The county does. In most cases, your buffer, and I don't have it sitting in front of me as to what it would exactly be at development review at that point. But there are different levels depending on, generally on width of the buffer and the amount of plantings. We like vegetation. Our buffering calls for vegetation of different sorts. You have canopy trees, your understory trees, you have shrubs, supplemented with some type of fencing, and those options are available. To go above whatever the county standard, you could say, well, it's not my place to tell you what to say or what to offer. You could ask for increased amount of, say, understory type plantings. I wouldn't go in that direction with canopy trees simply because the root area is large for those. We need to have room for them to spread out. And you could you could make conditions about the type of fencing maybe, to supplement the vegetative plantings.
So if we simply amended the proposal to ask for more buffering and no more detail than that, how would the county respond? Or do we have to be specific?
I would, probably the easiest way to do that would go with a percentage. Increase the required buffering by X%. That would then give some leeway, because when you're talking plantings, these are natural things. Some adjustments would have to be made to have room for the various plantings and what they're planting and how, you know, its final size and denseness.
So there would be some leeway between the applicant and the county on determining what that would be?
Yes, sir. That's why I say a percentage would probably be the easiest. We could look at it and say, okay, it calls for, 100 bushes. Well, you want to bump it up? Okay, well, now we got to add 100, 25 more, something like that.
All right, thank you.
I have a question also, Drew. The first one is, can we require that if this is approved, this application, that the business not be open on Sunday?
You absolutely can impose conditions upon the use, okay, the use that's requested. I would not want to tread in the direction of saying a restaurant couldn't be open on a Sunday where a restaurant is allowed out by outright.
Or could we say that on Sundays that it would not serve alcohol?
So I look at my name badge and it does not say attorney. I'm not, I can't offer you a legal opinion on that. What I can tell you is you're here to address specifically the use of on-premise sales within that 1,000 foot of a place of worship. Conditions you could impose would deal with compatibility of the uses, which is why I mentioned buffering. and sure, that could impose, you could impose certain hours of operation. I would, like I said, I would be very hesitant to restrict what is allowed outright by zoning, which is the restaurant.
Mr. Chairman, one of the difficult things for me, District 1 needs restaurants and other kinds of amenities like that. And if you know about District 1 now, the Beulah area, there really aren't any restaurants, real sit-down type restaurants to be able to get a meal. So it's important that we have amenities in that area. The thing that troubles me is, Mr. Chairman, we have a church literally across the fence, as the testimony was, from the proposed applicant, and that troubles me a lot. It's one thing to be farther down the road, and we have had those situations before, but this is one where literally they're right next to each other, and that does and the idea that during Sunday services you will have the restaurant serving alcohol right across the fence, and it's a difficult. I understand the economic development part of it, and I am truly, Beulah needs these kind of amenities, but I just don't know about this, to be honest. I'd like to hear some other voices up
Randy,
here.
did you have a comment?
Just my comment was more about the added borders or hours of operation. I don't think any of that fixes the objection. The objection is more in the existence of, so complicating it with extra barriers and time restrictions, it would try to make us feel good about the decision, but it's not going to make anybody happy. I don't know the history of this, and I don't exactly understand the importance of it. Where I go to church, they serve alcohol during the service, so I don't have I don't have a personal objection like the members of this church do. So I personally don't. I'm more concerned about the mobile home park on the other side and the density of having other businesses, other than this restaurant. This seems like a fairly small piece of property to have all that other stuff, but that's not what we're here for. I would have more objections to all that other stuff than the alcohol. But then again, the handful of jobs right next to a mobile home park is probably increasing the value of that mobile home park because people can walk to work. So, but I don't think the complication of adding extra barriers and stuff is worth the time because it does not fix the objection. So that's my point.
Yeah, I think I agree, and you just reiterated that today we're asked to make a decision on whether to permit alcohol consumption within 1,000 feet of the worst place of worship. That's what we're here today to do.
I agree with them. Barriers won't fix the situation. One of my main concerns is the safety, the community, the children. They are our tomorrow, and we do have to protect those children. And everybody has a right to put a business wherever they can afford to put one, but we have to protect the safety of our children. We have to protect them because a lot of times they can't protect themselves. And each one of the board members This is a hard seat to sit in, but at the end of the day, we have to make the right decisions. And we have to be able to sleep at night with those decisions. So safety is my number one concern.
The chair will now entertain a motion regarding this item. In your motion, please state whether or not you adopt staff's findings of fact. If for any reason you do not accept staff's findings of fact, go through the criteria and address it. Chair's open for a motion.
I'd like to entertain a motion with the conditional use of no alcohol sales, restaurant only. Would that be the proper way to put it?
I couldn't hear you.
Deny variance.
It's conditional
Condi-
use.
Conditional use of restaurant only, no alcohol.
Sorry, restaurants aren't allowed use outright in that zoning.
Okay.
They would not even be here if it wasn't for the alcohol. So the request itself is to have on-premise consumption within 1,000 feet of a church.
Okay, so it'd be deny the request. What would be the proper way? And I'm not trying to sound like dumb, but what would be the proper way to and just make sure that the restaurant is there and with no alcohol sales? I want.
So.
Okay.
I
So
believe Mr.
The
Ponson
motion, as I
answered.
understand it, is to deny the conditional use request.
Yes.
Period. We seek a second.
I'll second it for discussion, Mr. Chairman.
Okay, we have a motion by Willie, a second by Michael, open for discussion. The motion is to deny the conditional use request allowing alcohol consumption within 1,000 feet of the place of worship. Questions?
just I guess a question for the attorney once again. I know you answered this, but I just want to be sure at this restaurant, the majority of the sales and the way it would be able to maintain itself would not be from alcohol sales. Is that true?
That's correct. The primary purpose would be the service of food.
Okay. I just wanted to make sure I understood that correctly.
Okay.
Correct.
Okay, call for the vote. Those in favor signify by raising your right hand. Those opposed? 3-2, passes.
Mr. Chair, I would ask that you have the movement notate which criteria he felt were not met, and offer it, because in order to deny the motion, the board needs to address the criteria and note which criteria were not met by the county and by the applicant. So I would ask that you have that clarified.
There are 9 criteria. If you would go through those, remember, if they, yeah, I'm going to pull that up. Essentially, if they don't meet all of those criteria, that's where it would be. But you're going to have to decide which. Where is that? Here we go. Okay, so what I'm gonna do is I'll go through the criteria and just essentially as a prompt, and you take where you wanna go from there. So that first criterion was the general compatibility. The second is the facilities and services. Third is your on-site circulation. Fourth, nuisance and hazards. Fifth is solid waste service. Sixth is screening and buffering. Seventh is signs and lighting. I shouldn't have done this by numbers, should I? Eighth is the site characteristics. and 9 is the use requirements for that specific district and use.
Be the use requirements.
I think definitely D.
Mr. Chairman, it looks like surely the intensity and the operation of the use and with its close proximity to the mobile home park next door, with children coming and going, I think that's one of the things that we would need
True.
to look at.
So that's the 1,000 foot minimum distance is not achieved.
No, we're here because the 1,000 foot is not achieved. That's
Okay.
that's a statement of fact. I would just ask that, Mr. Kirkland, if you want to amend your motion and add those, just if you could keep it very straightforward, because I got to write all this down.
Okay. I'll say criterion D.
And can we go on down past D a little
I
bit?
think F should be considered optional there.
Okay. Criterion D, F, and I. Mr. Chairman, so that's criterion D, F, and I would be.
D and I and F.
Yes, sir.
D, I, and F. Okay, any other comments regarding this case? The next meeting will be Wednesday, February 16th. Staff have any thoughts as to the next meeting? Do we have a case?
Yes, we have at least one conditional use that's coming back.
Okay, board members, any comments? Without objection, we stand adjourned.